welcome members to this, the CQS, the new assessment regime and latest guidelines talk with CQS lead assessor Tracy Thompson. And this session is one of a variety of webinars available free of charge to Surrey Law Society members over the course of this year. And as you can see, a selection of the forthcoming webinars is available to view on your screen now. And the Society also, as mentioned on the slide, has a full program of more intensive training available, where there's longer online sessions and in-person afternoon courses. And you can view the full program at www.surreylawsociety.org.uk. But anyway, housekeeping for this one. So if you, as displayed on the screen, if you have a question that you'd like the speaker to answer, you can ask this using the Q&A facility within the Zoom. If you would like to speak to Tracy at the end of the session, you can do this by using the raise hand function. And as mentioned in blue, this webinar is being recorded and will be made available to members after the event. But as the housekeeping out of the way, but what will the session actually involve? And so, as you may remember, that the CQS scheme rules are intended to be a working document with updates being made as required following changes to the standard, incorporating relevant legislation and suggested best practice. And it's all following the Law Society Conveyancing Quality Scheme assessment pilot of late 2019, early 2020, and the formal commencement of the new CQS assessment regime, which is imminent once the pandemic allows, possibly from April 2022. So Tracy is here to provide insight into conveyancing practices and ongoing updates to the CQS scheme, and to identify practices in which particular areas of difficulty there are in demonstrating compliance for firms, as identified during the CQS assessment pilot. But anyway, enough about what this is going to involve. Let's get on to it. I'll hand over to you, Tracy.
Thank you. Let me just share my screen so that everybody can see my slides. There we go. Thank you very much. So hello, welcome everybody. I am pleased to be able to speak to some of you again. For those of you who may have attended the CQS course that I ran for Surrey Law Society back in 29th of January 2020 it was. I've just checked on that. Seems an awful long time ago now. But you may have heard about CQS previously from me, so I'm going to give you an update as to kind of what's been happening since then, and let you know any key areas of difficulties that firms particularly struggled with during the course of the pilot, which we undertook from November 2019 through to February 2020. I'm going to feedback on the results of the pilot, talk you through the key areas of difficulties, A, that were identified in the pilot, but B, that we're still identifying from firms when talking to them in general about CQS over the last couple of years, but also when we're going out to do Lexel assessments as well, because there is, a significant overlap between CQS, Core Practice Management Standards, and the Lexel standard as well. So we're still seeing kind of similar problems coming through from practices. And just to give you the update on what is happening with the scheme in terms of kind of any revisions and the on-site assessment and what that looks like. So for those of you who may have attended that course back in January 2020, you will have had some information, comprehensive, working through the 34 requirements of the Core Practice Management Standard, and you will hopefully be some way on your journey to complying with the Core Practice Management Standard and the protocols, and you may have heard some of the things that I touched upon today. So I make apology for any duplications that those delegates might have today. For those of you who are new to this and haven't listened to me talking about CQS before, then I'm going to make certain assumptions. So those assumptions will be that obviously you're a residential conveyancing practice, you have CQS accreditation, and that you have kind of engaged with the core practice management standard and are aware of what that looks like and what the CQS scheme looks like, and that in turn will obviously lead to you having some kind of knowledge or appreciation of what it is that you're supposed to be doing in practice. So I will make those assumptions. If you have never looked at the core practice management standard, CQS scheme rules, the protocols, then when we get to the end of today's session, you might want to go away and actually have a look at them, and then it might all fall into place and make a little bit more sense for you. So going back to kind of where we were, so 2019 we had the revisions to the CQS scheme. And we had the introduction of the new core practice management standard, which came out in May 2019. And that core practice management standard included, some new requirements that particularly dealt with the particular risks that were being seen in residential conveyancing departments throughout the legal profession at that time. And then we also had new protocols that they were rolled out in August 2019 and became compulsory to follow those protocols at that time. But probably the most significantly, we had the introduction of the CQS on-site assessment. So the on-site assessment pilot, which we carried out between November 2019 and February 2020, involved the Law Society and myself and my team of assessors going out to a number of practices around the country, and carrying out a full on-site assessment, which looks very, very similar to a Lexel assessment for those of you who are Lexel accredited. So the pilot itself involved one day on site, regardless of the size and nature of the practice or the conveyancing department, and it involved, an opening meeting, obtaining open and closed file lists, having conversations with the SRO about the practice and any issues within the practice, and then we reviewed all the policies and procedures as required by the core practice management standard. We reviewed files that we selected from the open and closed file list, so that included sales, purchases, leasehold, freehold, titles. And then we conducted reviews of central records, which are things like undertakings records and financial records of the business, and also things like file reviews as well. So those are documents that we consider to be central records. And then finally, as part of that assessment, we undertook interviews. Majority of interviews were with fee earners. I'd probably say 70 to 75% of the interviews took place with fee earners. However, as part of the selection process made by the Law Society, they indicated to us as to who we were to interview based on the register that they have in their possession at any given time for CQS accredited practices. So we also talked to key support staff, to accounts departments, to finance directors, as well as obviously head of conveyancing and the SRO, and the fee earners that were selected, and that was both qualified and unqualified fee earners. So in terms of kind of what the assessment looks like, when we did the pilot, that's what it looked like. Going forward, it's unlikely to change, although obviously in terms of COVID and kind of this, in and out of restrictions that we have, we may be looking at something other than the assessor being sat in your office for a full day. It may be that some of it's carried out remotely, and the time in the office is reduced or restricted. It really all depends on kind of how things go in terms of what COVID looks like going forward. But ultimately, that's where we were in 2019. We're now in 2020. The Law Society have not been resting on their laurels during that time. They have been undertaking what we always knew would be kind of review and reflection based on the outcome of the pilot. As assessors, we took on board certain considerations for how we felt the process could be improved. Fed that back to Law Society. Obviously, we got a lot of feedback from the firms that we actually went out to assess. Some of it positive, some of it negative. Again, all fed back to the Law Society, and then on the back of that, obviously, they were always going to carry out their own process of review in terms of the procedures, the process, the time frames, the documentation, the guidance, etc., etc. So they have been working in the background over the last couple of years, and things are about to kind of start moving again in terms of this new regime going forward. So just before I feed back to you in relation to the findings from the pilot, one of the most important things that I want to tell you about, and if you've heard me before, you'll recognise this. It's I always say it's the most important slide that I kind of show to people whenever I'm talking about CQS. It doesn't matter who I'm talking to. This is the most important thing that I want to take away from today. If you've heard from me before, it won't come as a surprise. If you haven't heard from me before, then please do just kind of remember this, really. And it's what I talk about as a 3-tier process. So the most important thing that you can do to demonstrate compliance with not only CQS, but with any quality management standard, with any regulatory requirement, with legislative requirements, is all about this 3-tier process. And that is all about say as you do as you say, and provide the evidence. So it's really, really key to make sure that you say as you do. So this is all your documented policies and procedures. So everything that falls within CQS, within the core practice management standard, needs to be written down. Okay, so a procedure as well as policy must be written down. And ultimately what that is a set of steps that you will take to achieve an outcome. So if we look at each individual requirement as an outcome, that's what you need to achieve. Make sure that you look at what the core practice management says, that this is what you need to achieve, and then write your policy, or obviously update your policy or amend your policy to make sure that you're reflecting what it is you're supposed to be doing, and then set out your stance that this is what we do in our firm. Okay. Then the next part of that process is to actually do what it is that you say you do. So there's no point in having a policy that says you will follow A, B, and C if we actually come in and do the assessment and find that in that particular regard, you actually follow A, D, and F. You do something completely different, because then what you'll find is that you're in breach of your own policy. So you'll come away with non-compliances. So you really do need to make sure that you've got that alignment between say as you do and do as you say. And key to that is consultation. It's, having open dialogue with the team, with the department, to actually, make sure that there is a conduit between the policy writers, the partners, the managers, and the people that are doing the job. Now, it doesn't matter whether that's the fee earners, whether it's, paralegals, whether it's secretarial staff or administrative staff. Anybody that's working in that department is expected to follow those policies and procedures. Needs to have the opportunity to kind of put their hand up, I suppose, and say, yeah, we do that in the majority of matters. However, there are occasions where I've had to depart from that. So then it's a decision of the partners as to whether that is acceptable to depart from that particular policy, and that's a decision made by the partners based on risk, and whether it's proportionate to the risk profile of the practice, and if it is acceptable, what are the parameters? If you can depart from your set policy and procedure, is it acceptable, but it needs to be signed off by somebody, it needs to be authorised, or these are the parameters? What does that look like? And if it is acceptable, then update your policy. So again, you know, you've got that situation whereby this is the standard, but on occasions we may depart from this policy, and this is what happens. And then when we come in and do the assessment and we pick up a file, because invariably, I don't know how we do it, but we do have this knack of picking files up where that policy hasn't been followed. And we see the departure, and then you're according with what you say that your policy is. So that's really, really key. So say as you do as you say, make sure the two things are aligned, and make sure that you converse with people. And then just as important is the third part of the three-tier process, and that is providing the evidence. And so we always need to make sure that the file tells a story, it demonstrates the journey, and that and everybody knows kind of what the evidence would be for that particular requirement. So, for example, it doesn't matter whether it's your CQS assessor, or whether it's the National Crime Agency, or whether it's the SRA. If you haven't got the evidence on that file, it didn't happen. And that's the key stance of an auditor or an investigator or an assessor, is that file should be able to be put in front of whoever it is that's reviewing it, and there should be evidence on the file that an action happened. So I'll give you an example of one of the non-compliances that we tend to see a lot of, not only in CQS but also in Lexel as well, and that is there is a requirement under CQS and Lexel to check the identity of the other side conveyancer. Okay, so hopefully you have a policy that is documented that says that we will check the identity of the other side's conveyancer by doing X, Y, and Z. And it might be that you've got two different stances. It might be that you have a stance for local firms that are down the same, down in the same town, down the same road, that you deal with on a day-to-day basis, and 70% of your transactions involve these other firms, so that you know who they are and you're confident and comfortable with that. And it may be that your secondary stance is anything that falls outside of those parameters. So if we're based in Guildford, and we are instructed on a matter, and the other side is based in Newcastle, then we have a different stance. And it might be that that stance says that we will go on the Law Society website, we will check the identity of the conveyancer, we'll go on the firm's website, we'll call them, whatever it is that you do, it is not good enough to put a file in front of an auditor or an investigator and to say, I would have done it. Okay, so you always need to have the evidence. And I use that as an example because quite often that is what happens. We'll have conversations with people as part of that interview process to say, how do you check the identity of the other side's conveyancer? And hopefully they'll say, oh, this is what we do A, B, C, and D. And then we'll look at the policy, and that should accord with what it is that the policy says. And then we'll look at the file, and that's where we're looking for some kind of proactive process that's been actioned to evidence that has taken place. So that particular requirement, we'd be looking for a screenshot or printout of the Law Society website, the firm's website, an attendance note, for who was spoken to at what time, on what number. So some kind of evidence. And obviously that kind of situation, you're looking for, it's about managing the risk, making sure that the conveyancer on the other side is bona fide and you're not dealing with criminals. So, it's you wouldn't be good enough to put that file in front of the National Crime Agency when, you've got a file production order to say, well, we would have checked them, or I'm sure I did. You need to have that evidence. So from a business owner's point of view, it's key because your fee earner might not be there any longer. But from anybody's perspective internally, it's all about the evidence, because you've then got a defence from the outset rather than being on the back foot. So yes, the most important thing that I ever say to anybody in relation to CQS is 3-tier process. Say as you do as you say, and provide that evidence. So we did this pilot, and we saw lots of firms, and we saw a multitude of different profiles of firms. So we saw firms that were sole practitioners with very little assistance, kind of part-time bookkeeper who comes in, and we saw firms who were large regional practices with 20 plus partners, 80 odd people in the conveyancing department. And we saw Lexel accredited practices, non-Lexel accredited practices, and we saw some really, really, really good firms, which is actually really good news. But we also saw some firms that didn't quite hit the mark, and quite a few of those. And this is everybody's opportunity to up the game, to improve their professional standards, as well as obviously making sure that they're going to be compliant with CQS and not, and on the back of that, legislation and regulation, because obviously there is a certain overlap. What we did see is within the firms that that weren't hitting the mark, we saw borrowed policies, which is not a good thing when we actually are in a firm, with one name and we're reading a policy that is named for another firm. So I think that was probably sheer panic with the practices that found themselves in that situation. And templates. So we saw a lot of templates. Templates are fine as a starting point, but that is what they are literally. So, you do need to ensure that if you have template documentation, wherever you've got it from, whether it's the CQS handbook or whether it's a compliance company, then do make sure that you then cross-reference that with what actually happens in your practice to make sure that you adapt it. So it talks to us as if it's about your practice and not very general policies. We had sight of a lot of outdated policies. So I actually had to look up when soccer no longer became a relevant organisation, because I was starting to read it so much. So I think it was about 2000 and I don't know if it's 10 or 13 now. Anyway, it's not been around for a long time. So we saw lots of outdated policies, some more so than others. Did actually read about Code of Conduct 2007, lots of money laundering regulations 2007, and obviously outdated data protection legislation, etc., etc. So if you do have policies and procedures in place, then do make sure that you just review what you do have, and that get a fresh pair of eyes on it to look for those outdated references. And we saw a lot of policies that were just not compliant with the core practice management standard. So it's amazing how many practices had not read the core practice management standard before an assessor was coming in to assess them. So kind of those were the general findings. When we looked at files, again, we saw the files weren't demonstrating what the core practice management standard required to be an outcome. So again, it's key. So not only having that 3-tier process in place, but actually starting off with what it is that you're supposed to be doing. If somebody says to you, you need to have an SDLT policy, then there's no point in just getting your pen and starting to write an SDLT policy without seeing what the core practice management standard actually wants you to achieve from that policy. So we also saw a lot of breaches of our own policy as well. So where we've got anti-money laundering, identification of clients, we will obtain forms of ID, one from list A, one from list B, and then we pick up a file and see that we have identification documents that do not accord with either of those lists, then that is a breach of the firm's own policy. So those lead to non-compliances, which is why you need to make sure that you've got that absolute alignment. And then key, lack of evidence. So just remember again, that third part of the process, that you always need to have some kind of positive action that demonstrates that an activity has occurred. Whether it's a tick in a case management system, whether it's a checklist that somebody ticks and puts their initials and date, or whether it's an attendance note, or there needs to be something that actually just shows that somebody is being accountable and saying, yes, that has been done. Or it might be that you run a task in your case management system and that then puts a note in history, or populates the conflict check that's been completed, or so there always needs to be that positive action, whether it's manual or generated by the system. And then we have interviews. So the interviews are nothing to be worried about. We just have a conversation with the interviewees about what they do and how they do it. And the ideal scenario is that their fallback position should be for them to just say, this is how I do it, so, talk to me about how you identify the other side's conveyancer, for example. Hopefully they'll just say, I would do this, that, and the other, and then that should accord with what is documented in the policy. So that's it's not rocket science. It's just talking about how you do things, and providing that process has been actioned where there is the alignment, there shouldn't be any issues. But what we did see is a certain inability for being able to talk about kind of what the firm's stance is on a particular requirement, or lack of knowledge of roles. That one's key. So we'll always ask the question, who's your MLRO, who is your COLP, who's your COFA, who's your data protection officer or data protection manager, those kind of things. So quite often we get blank faces, or it could be this person, or it could be that person. Obviously, occasionally we get, oh, it's such and such. So we just need to make sure that everybody knows, who performs what role, because in the situation whereby you need to approach that person with an issue, then obviously that should be an easy process to know who to go to. And then general understanding or lack of understanding of CQS. And I've said, on many occasions that, I do a lot of consultancy work, speak to a lot of people in a lot of departments. And talking to junior members of staff quite often, CQS to them can just be pretty pink logo at the bottom of the letterhead, or the sticker on the front window, or the door into the office. And they don't necessarily understand what CQS is all about, how important it is to a conveyancing practice, and how, obviously there could be ramifications for any suspension or loss of the accreditation, and what that would mean to the practice. So it's really important that everybody understands that CQS is important, and this is what CQS looks like. So I've been running a lot of training sessions recently for CQS compliance for support staff, and particularly in-house as well, so that everybody within the department knows that this is what the core practice management standard looks like, this is what CQS looks like, and this is actually the part that everybody plays in making sure that not only you're complying with CQS, but you're helping support the fee earners, you're all working as a team, everybody plays a role in making sure that what is supposed to be getting done is done, and it is recorded, and there is evidence on the file, and everybody plays their part in that, regardless of what job they do. But also, that goes some way to making sure that you're complying with, legislation, with regulation, as well, because it's not just the CQS assessor that will be looking at your files. If you've not had your visit yet from the SRA as part of the AML thematic review, they will be coming within the next 2 years, and they will be in a situation whereby they're having the same review of files, looking for the same evidence, looking for the policies, previous policies, talking to people, and generally will be following the same kind of process. So it's really important that everybody knows what role they play and what these things look like, and they need to know what the core practice management standard looks like, and they need to know about the protocols as well, and that does actually form part of the training requirements that are specific to CQS. So just to kind of point out to you, if you don't know already, core practice management standard, 34 requirements. Some are one line, some requirements are far more complex, like the anti-money laundering policy and data protection policy. When I run my 3-hour course that some of you may have attended, that kind of goes on to two slides, 8 to 10 and more different sub requirements. So some of it's quite complex. Some of the standard is only for the partners and management team to deal with, so high level finances and profit and loss and things like that, so doesn't really affect fee earners or support staff. But two things worth remembering, and that is that the standard is not prescriptive, so it's up to a firm to decide how you achieve the outcome. And there are minimum expectations, so like I say, make sure that you review the core practice management standard, because it's very much like outcomes focused regulation. This is what you need to achieve. How you achieve it is entirely up to you, so long as it's sensible and proportionate and logical, and you're able to have a conversation about it. So, the standard does not say that you have to do something in a certain way. It says that you've got to meet this outcome, and you decide. You've got to take into account your approach to risk and, what you consider would be the acceptable levels to be managing that particular requirement in your practice. So some practices are struggling with some of the key areas with core practice management standard, and my job today is for the rest of the hour is to just bring those to your attention so that you can hopefully conduct a review, make sure that you are kind of picking up on those areas where practices are struggling, and I'm talking about practices that that are wanting to do the best. By virtue of the fact that I have a lot of people jumping on these courses in relation to CQS, whether it's for fee earners, for partners, for support staff, whether it's specific individual requirements in relation to price transparency or anti-money laundering or anything like that. By virtue of the fact that you are all engaging with this, you, I assume, want to be the best firm that you can be and want to make sure that you are following the standard, and hopefully that's because you want to ensure that you're managing the risk in your business as best you can. And we see quite typically where there is an overlap with Lexel, we do see some some of the same kind of areas where practices struggle to just make sure that they are covering all the risks in certain areas. So what I've done on my slide, where I kind of just want to draw your attention to where you may need to just have a look and see if you are kind of dealing with the process as best you can. The particular requirement is on the slide. The area where practices are struggling generally, and from patterns and trends that we've seen, not only from the pilot but from firms that we see on a regular basis since then, for other issues, then that particular requirement is highlighted red. So in relation to the risk management policy, a lot of firms will have a well documented and comprehensive risk management policy, setting out all the things that they need to ensure that they're complying with the regulatory obligations and they're managing the risk in the business, and they've got a compliance plan. However, we do see risk registers that could do with some improvement, and 2 points to that really. One is, be aware that the risk register, as required by the risk management policy, is not the same as your business continuity plan. Okay, so the business continuity plan is aimed to deal with short-term significant interruptions to the business now. Okay. And obviously, we've all, over the last couple of years, everybody has incepted their business continuity plan, whether they actually had one or not. Hopefully now, that's there's been a learning curve for everybody. The risk register is intended to be, an all-encompassing register, documented list of, the risks to your business. And and there's lots of different significant risks to business. Obviously, we have all the different categories of risk, like financial and operational and strategic, and and regulatory, and etc. etc. But that risk register should then kind of break that down. So financial risks are complaints, client complaints, potential negligence claims, breach of solicitors' accounts rules. Then we have regulatory risks, which examples would be failure to comply with the solicitors' code of conduct for firms, and code of conduct for firms and code of conduct for solicitors. And then we identify in that risk register how we are going to manage those risks. Strategic risks could encompass lack of instructions. So we've got the estate agent next door that gives us a lot of work, and refers clients to us because we are well placed for dealing with their clients because we're next door. And where are the risks in, in that that business, continuing, or lack of client instructions is a risk, or lack of, maintaining our fee structures is a risk to the business, and how can we try to mitigate that, and what are the actions that we need to do to ensure that we manage those risks and balance it going forward. So make sure that there is that the differential there between risk register, which is risks to your business and keeping your business going and sustaining the business, and business continuity plan, which is we can't get into the office, or all of our staff have gone off COVID positive because we've not got an appropriate COVID risk assessment in the firm. So two very different things. The other thing I'd say as well is that don't see very much of loss of CQS accreditation listed in a risk register. Occasionally see Lexel for firms that are Lexel accredited that might have a legal aid contract that is based on the fact that they're Lexel accredited. Obviously, if they fail to achieve or to maintain their Lexel accreditation, then they wouldn't be able to provide services under that legal aid contract. So that's a huge risk. Similar thing with CQS. Without CQS, you won't be able to meet the criteria for a lot of lenders to go on the panels. So you won't be able to act for the lenders, and therefore that's going to have a significant risk to the conveyancing department, as a whole. So make sure that you do give consideration to CQS, and that's any compromise to that accreditation would be a risk to the business, and what you're going to do about it. And obviously, your starting point is to listen to things like me today. So moving on to another area where firms are struggling, and that is SDLT and LTT. So depending on whether you're dealing with properties in England or Wales. So this process is kind of generally, we're talking about all of it really, where firms kind of haven't quite got their head around what it is that they need to be doing. So it's quite simple, although the wording might not necessarily reflect that. So you need to have a policy that sets out how you would deal with this whole SDLT and LTT process and calculation. And you need to include in that how you are getting the information from the client to be able to make the calculation. So chances are that will be, we take the call, we give a quote, we make a calculation based on, the initial information that we've been provided with based on the price of the house. And then we send out the client care pack, and within that is a questionnaire maybe, that we set some advice out to the client or give them some information, and then we ask them for information. We get that back, and then from that information we can then establish the full and proper SDLT calculation based on whatever reliefs that they're relying on, or whether there's an annex to the building, etc., etc. So that is the audit trail for the SDLT calculation and advice. So that's what we're looking for. There is then the procedure. I would swap these around if it was me, but so then we have this additional procedure at 1.2c, whereby there needs to be a second pair of eyes on that SDLT calculation. So again, not prescriptive, so how practices choose to do this is up to you, but you do need to have somebody checking that calculation at a different point in time. So obviously, if you've got a situation whereby a file is signed off for completion or exchange, then it could be that whoever does the sign off then checks the SDLT is the correct calculation. Or it could just be another person as part of a process, whether it's the cash office or the accounts department. But there does need to be a second pair of eyes on that SDLT calculation. The only exception is where there's a sole practitioner who works on their own and there isn't anybody to do it. But then we would suggest that that would be a different calculation using a different method, to double check. And then we have this final requirement, which is the correlation of the figures contained within 4 documents. So there needs to be a physical check of the numbers stated in the contract, the transfer, the SDLT return, and the client ledger. So it has to be after the SDLT or LTT payment has been made. And what you're looking for there is anomalies. So you're looking for mistakes, that these documents show these figures and that should have been the amount that was paid, but it wasn't. So, errors. or deliberate mistakes. So deliberate fraudulent activity, which is something that I am hearing, or we're hearing more and more of now, which is kind of deliberate attempts to circumvent some of the money to a criminal or a fraudulent member of staff. So you're looking for anomalies, and to be able to do that, it's not good enough to say, there's the file, all 4 documents are on there. That's not good enough. So that's like I would have checked the identity of the other side's conveyancer. There needs to be some process that you put into place that says somebody is accountable for looking at that, and that together. And then there is that positive action where somebody either signs a checklist and puts their name to it to say, I'm accountable for the fact that I've checked that, or they tick a box in the case management system, or they make a file note, or whatever it is. There needs to be that positive action, and that is the evidence that the check has been made. Or you might just have, you might have a form that you develop that just, is completed. So again, whatever you decide to do, you need to incorporate those processes into your SDLT and LTT policy, and obviously make sure that everybody follows it and you've got that evidence going forward. So that's an area where firms are struggling at the moment. In terms of anti-money laundering, obviously, it's huge in relation to residential conveyancing and what you should be doing and what you should be looking for. Hopefully you are all aware that there was the draft ELSA guidance issued in January last year, and you have reviewed your policy on the back of that. If you haven't, 212 pages of bedtime reading for you. Make sure that you review thoroughly all the guidance and cross-reference that with your anti-money laundering policy to make sure that you are following the latest guidance. In particular, firms, may be struggling, or where we've seen firms are struggling with the practice-wide risk assessment, and obviously this forms part of the SRA's AML thematic review, and there was the COLP had to declare. I can't remember. I'm mixed up whether it was a year ago or 2 years ago now. But I think it was January 2020, whereby there was the declaration that was sent out to all COLPs in the practice, where they then needed to certify that they had Regulation 18 practice-wide risk assessment in place, and that it contained various pieces of information. And of course, as I say, the SRA are now doing the thematic review. One of the first things that they're asking for is your practice-wide risk assessment, your current version, and also any previous versions as well. So obviously they are looking to then kind of demonstrate that you have reviewed it on the back of the ELSA guidance from January last year, because that would have been a trigger to review all of your AML policy and corresponding procedures. And whilst it's not specifically documented in the CQS standard or in Lexel, there is that requirement under Regulation 28 of the legislation that you need to have your matter-based risk assessment for anti-money laundering. And whilst it's not specifically referred to, obviously I have highlighted here to ensure compliance with anti-money laundering legislation. And as I say, Regulation 28 means that you not only need to have your practice-wide risk assessment, but you also need to have a specific risk assessment on your individual conveyancing files. So that's something which that we're seeing firms struggling with. Procedures for checking source of funds. Make sure that you know the difference between source of funds and source of wealth. Again, something that the SRA are asking for your source of funds policy, and all corresponding documentation in relation to the files that they select to review. So source of funds is, is getting evidence of the existence of the money. Source of wealth is getting evidence of how that money has been accumulated. And obviously that's where you want to go to make sure that, that you are not dealing with any tainted money and proceeds of crime. And the same applies for a client as it does to any third parties who are providing the funds for a transaction, particularly in residential conveyancing. So just make sure that that is an area that you specifically review. And then for the first kind of probably 3 years of the money laundering regulations, 2017, we had a lot of firms that would identify that, oh yeah, we've seen that, you know, we're appropriate with regards to the size and nature of the practice. We need to appoint an MLCO, screen employees and have an independent audit function. However, we decide that we are not of the size and nature of the practice. And we saw an awful lot of that, and I'm still seeing an awful lot of that as well. Anybody who jumped on the virtual Culp and Coffer conference back in November 2020, you will have heard the SRA quite clearly making the point that that they expect the majority of practices who practice in residential conveyancing to comply with this particular requirement. So your MLCO, appoint one of those, needs to be a board member, screen relevant employees in terms of their knowledge and the potential criminal history, so DBS checks, and you need to establish an independent audit function so that somebody is having a second pair of eyes on those files to make sure that the policies fit for purpose and that people are following them. Doesn't need to be independent of the firm. It can be. It's, you know, it's good to have somebody impartial that's got no bias. However, it can be somebody that is just removed from any particular significant roles. So not the Culp, not the MLRO, not the MLCO, not the head of conveyancing, but somebody who is trained in anti-money laundering, understands what it is that they should be looking for, and is competent to carry out that function. So that's something that if you're not doing that already, it is one of the things that the SRA ask you for when they notify you you've been selected for a visit for the thematic review. They ask for your audit records. So moving on to property and mortgage fraud, just keeping an eye on my time here. You will see that there is a requirement to obviously check the identity of the decides conveyancer. We've already spoken about that, make sure there is evidence, but you also need to have a risk assessment on your file as well in relation to fraud. So this is on the back of Dream Bar, and you know, we are looking for risks of fraud in relation to acting for our client, but also where there is significant risk of fraud. We're acting for the buyer and there could be a fraudulent seller, as in Dream Bar. So make sure that you do have that that fraud risk assessment. Now, it can be the same document as your anti-money laundering risk assessment. However, it does make sense to kind of keep them separate so that there are different considerations and there's no ability for people to get confused. But there's nothing to say that it can't be the same document. However, you do need to assess the risks of anti-money laundering considerations and fraud. And we're seeing a lot of that missing as well in conveyancing files. Leasehold property policy, again, you know, a lot of leasehold property information is being fed back to the client in the report, you know, 10 weeks, 12 weeks down the line as part of a 28-page report on title that's talking to them about the title, search results, you know, here's a copy of the lease, you know, and buried in there is a little bit of information about the fact that, you know, the length of term remaining is 86 years. You are advised to do a quick letter to the client at the point of receiving the title information document and the contract documentation to just point out to them quite candidly that you're buying a right to live in this property for 86 years. It's leasehold. Here's a leasehold information leaflet if you have one, or here's a link to, I don't know, the leasehold advisory group, or, you know, somewhere where they can get more information. Just set out to them, this is your ground rent, this is service charge. It will be reviewed, you know, in this way. We will make more inquiries and we'll report to you fully when we have the management inquiry responses, etc., etc. Don't assume that just because, you know, somebody's buying a flat that they know what that means. You know, they don't necessarily. And some of you, I'm sure, will have had some files called for by, you know, firms that are acting speculatively on the back of, you know, leaseholders that are, you know, looking to make claims, which is a headache. You know, even if it doesn't turn into a claim, it's still a headache to have to deal with it, and then you start having to notify your insurers of, you know, and obviously move into kind of territory that you don't really want to. So the easiest way of dealing with that is just to set something out to the client very early on in very plain English, and then report to them later on. And you've told them twice then, so you've got some kind of defence going forward. Business continuity plan, as I said, don't get that mixed up with your risk register. Business continuity plan, we've all executed one within the last 2 years. You know, everybody's working at home from Monday. You know, pick up your desktop and off you go. Best test that you could ever have had. So document it. Document what you've done and how you've done it, what worked, what didn't work, what you changed on the back of what didn't work, and how you will, you know, how you will work going forward. But regardless, you need to have a procedure to test the plan annually. That means the plan needs to say, on an annual basis, we will test the business continuity plan by doing A, B, and C. Okay, so it needs to make reference to your annual procedure. That procedure might be that, you know, once a quarter on a Saturday morning, we'll transfer all the phones over to everybody's mobiles. We will we'll get everybody to log on to the VPN at any one time to make sure that the servers still have the capacity to deal with that. Because obviously, you know, when we went since the first lockdown, one of the first things that people found, or firms, organisations generally found, is that nobody's ever tested 200 people logging into the VPN all at the same time on 9 o'clock on a Monday morning when the whole of the country was using up all the bandwidth, you know. So these are the kind of things that you need to test, because you don't want to find out it doesn't work at the point where you need it. Or, you know, for other things, there's scenario testing as well. So you can have a group of people who sit down and say, right, what would we do in this scenario? We've got COVID in the office, you know, somebody hasn't tested, they come in, everybody's got COVID. And, you know, we've got some people that are ill, that can't work, and we've got some people that, you know, that are, you know, well enough to be able to work from home. And how are we going to manage this scenario? You know, and then you can brainstorm, you can document it, just make sure it's documented, because that's your evidence. And what would work, what wouldn't work, what can we test as part of that, and what can't we? You know, but Law Society are really keen on testing business continuity plans, always have been, but even more so now. So you do need to make sure that you've got that in place, and it is an area that we see firms not complying with. Supervision procedures are different now to what they were prior to March 2020. You know, your post used to come in, the junior opened it, stamped it, took it up to the senior partner who initialed it, took out anything from the SRA or any complaints, passed it back to the junior, who went then put everything in everybody, you know, every fee earner's pigeonholes. We don't look like that now in our offices. So just make sure that you review your supervision procedures to make sure they actually reflect the post-pandemic world of what your office looks like. And similarly with you know, meetings once a month in the boardroom used to be what, you know, departmental meetings look like. Now it could be something completely different on Zoom, or communication structures might be by WhatsApp, etc. So so yeah, so just kind of look at the position now and not look at the position how it's always been. Training policy. Make sure that everybody is aware of the core practice management standards. I've already mentioned, as part of the pilot, we kind of came across a lot of blank faces and not really understanding what it's all about, and that was from you know, senior partners and managing partners and colps, as well as, you know, as you know, support staff and fee earners, and make sure that everybody is aware of the protocols. Apart from anything, the protocols are really interesting. I sound really sad saying that, I know, but you know, for you know, for somebody in the conveyance department that hasn't actually looked at it before, to see what is supposed to happen, when it's supposed to happen, and who is supposed to do it, it's valuable information. So so make sure that, you know, you do have some process in place to ensure that that everybody is aware of what those protocols look like. And remember, the lower the number, the earlier in the transaction it's supposed to happen. So source of funds, number 7 in the protocols, should not be getting, you know, should not be getting attention at the point of just before exchange of contracts, 14 weeks down the line, when someone's done a completion statement and realised £70,000 coming in from, you know, as a deposit. Can we please have your bank statements, and start that whole process? Because of course that's going to cause difficulties going forward with everybody else in the chain, and in particular with the client. File reviews. So we see a lot of issues with file reviews, particularly for those firms that are not, you know, that are not Lexel accredited. Even if you are Lexel accredited, regardless of whether we've had a pandemic or people have been working at home, we still expect to see the file reviews in place and done in accordance with your criteria. For CQS accredited firms, if you haven't started a file review procedure, make sure that you do start it, because we will be focusing our efforts quite significantly in file reviews, because it's the best data that you can get. How a fee earner is running a file, whether they're complying with your policies, your procedures, legislation, regulation, and what they're doing and how they're doing it, and the timeframes that they're doing it within. So there's a lot of valuable information in there. So just make sure that that you realise, and particularly if I've got any sole practitioners here today, that this is a must. So practices must have a procedure for file reviews. That applies to everybody. There is only one should in CQS, and that's about Cyber Essentials accreditation. So if it's a must, you have to comply, regardless of the fact that you might be the only fee earner. There are different ways of being able to deal with that. So you might have a competent competent support staff that could be trained up to review files, or peer-to-peer reviews with other firms and other contacts that you have within the legal profession. So file reviews are key. We expect to see them, and we expect to see a decent amount of file reviews being done as well. So one file per quarter for a newly qualified conveyancer who's only been with you for 3 months is not going to be acceptable. So give consideration to the exposure of risk. Conflicts policies, we see a lot of normal conflicts policies, but the additional steps that are required by CQS for what you're going to do if you act on both sides of a transaction, different fee earners, different offices, locking down case management systems, that kind of thing. We see a lot of that missing. And then what happens if 6 weeks down the line, clients getting into an argument with you? This wouldn't have happened if you hadn't been acting for the seller. So what happens then? And then how are we managing possible conflicts between the lay client and the lender client as well? So these are areas where we're seeing are kind of not being considered as part of the conflicts policy, and are being missed off because the CQS exclusive. So it might be that just nobody realises that you need to have these things in place. Transparency rules, again, part of the SRA's current business plan. They are sweeping through firms' websites to make sure that that every firm is complying with the transparency rules. Make sure that that is on your radar, because I'm getting more and more people contacting me to say, I've had this letter from the SRA, can you help me? So have a good review of what it is that you need to be doing. So it's not just about price, it's about service, it's about people that are doing the work, it's about their experience, it's about costs, VAT, disbursements, your complaints procedure. Make sure your complaints procedure actually covers off everything that the SRA say you should have in your complaints procedure, because I've had somebody contact me over that last week. And so complaints, and also your digital badge as well. Make sure that that is the correct digital badge on your homepage of your website. And then matter progression procedures. So something we see a lot of is when cost estimates have been increased, then the client hasn't been informed in writing prior to those costs being increased. So make sure that that is something that's on your radar. And also when the fee earner or the supervisor or the complaints partner or the person that deals with the complaints has been kind of notified to the client at the outset. If any of those three roles change, then the client needs to be informed in writing that the fee earner's changed, or the supervisor's changed, or it might be both, depending on if they've moved to a different team. And like I say, any complaints information that you've given them at the beginning of the transaction, if that changes because the senior partner's retired and now somebody else has taken over the complaints, then make sure that you tell that client in writing. And then key dates. So key dates have to be recorded in 2 places. So identify what your key dates are. So expiry of the mortgage offer, OS1 expiry, completion date, those kind of things. Record them and make sure that they are recorded in a secondary backup system as well. So it's that backup system that quite often is missing when we are talking to firms. And then closing procedures. So hopefully you are aware that there is the requirements under Core Practice Management Standard and also the protocols to Inform the client about HMLR property alert service at the end of the transaction. So again, protocol numbers, it's at the end. I think it's number 31 or 33. You can tell the client at the point that you're reporting to them, that's fine, but you're giving an awful lot of information to the client at that point. So make sure that you tell them again at the end of the transaction. When you're sending them a copy of their title information document and you're asking them to complete a survey, and you're talking to them about wills and sending them anything, any documents back in accordance with all these particular requirements, that's when you need to either tell them first off or reiterate to them about this property alert service, which obviously could cause, could assist with any potential fraud. Data protection policy on the back of GDPR back in 2018. Majority of firms have got some kind of policy in place. What we do see is lack of knowledge in terms of I'm a fee earner, I've just had an email or a call from a client to say I want to make a subject access request. What do I do about it? So, we need to make sure that everybody understands what a subject access request looks like. It doesn't need to be in writing, it can be verbal, and what they do about it. So they need to know their own procedures. And also timeframes as well. So everybody should be able to answer the question, if you received a subject access request, what do you do about it, and what the timeframes that the firm needs to comply with. So the timeframes, obviously, if you're aware of that legislation, is 1 month from the data subject access request being made, plus 1 working day actually. And then similarly with data breaches. So, somebody sends something by email and then next thing you know, 5 minutes later, they get a response, which is, don't think that was for me. What do they do about it? Who do they report it to? Do they kind of just go, oh, never mind? They need to make sure that they follow your procedures, which would be to report it to the data protection manager or officer. And again, they need to know the timescales, that if this does turn out to be a data breach and the data protection officer or manager needs to report it to the ICO, that needs to be done within 72 hours of that breach coming to the firm's attention. And similarly, if it's something that needs to be reported to the SRA as a potential serious breach, then that would need to be reported within 24 hours. So it's key that that everybody knows kind of what those particular requirements of data protection compliance look like from an individual's point of view, and something that we saw a lot of. Finally, information management security. I've said that there's only one should in CQS, and that is that practices must have an information management security policy. That's compulsory for everybody. This is all the techie stuff. So this is all the, all the firewalls and software patches and making sure that the servers are configured securely, etc., etc. But firms should be accredited against Cyber Essentials. If you have chosen not to be accredited against Cyber Essentials, then you need to document why, and you need to have a sensible conversation with us as to why. Because of course, cybercrime is one of the key areas of concern for the SRA and for law firms. 65% of law firms, I think it's 60 or 65% of law firms, and since the beginning of the pandemic, have either been a victim of or an attempted cyber attack has been attempted on the practice. So, it's really, really key to make sure that you are as secure as you can be. And I think a statistic in relation to all crime, 75% of all reported crime in the last 12 months is cyber-based. So it's a huge risk to us as law firms, and for the amount of client money that you will be holding in your client account as well. So for the sake of 400, I think it's just gone up to £400. Cyber Essentials is a good thing to have, and there's not a huge amount of work involved, because you have to have all of these procedures in place anyway, and a lot of this information actually falls within the Cyber Essentials application. Make sure that everybody is trained on Cyber Essentials, because you're only as good as the person who is clicking on the links to expose the practice to those cyber attacks. So cyber training is imperative. And And then where we've got these procedures that are CQS exclusive, that are aiming to keep the practice's bank details secure and also the client's bank details secure, make sure that everybody is aware that Outlook is not secure. There should be some kind of verification process in place whereby you're having conversations with the client to verify the banking information that hopefully you've received from them in writing at the beginning of the transaction. If they're still the same, if they've changed, that you need to have robust systems in place to make sure that it is actually the client that is notifying you of those changes, and it's not a criminal which is going to then circumvent that process and send £600,000 sale proceeds to a criminal, which of course if you read the legal press, has happened in the past. So passwords, a lot of firms are now starting to use passwords. If you phone your online, if you phone your bank, you can't get anywhere without going through security. So we're talking about client data and a lot of client money that you're in possession of and moving. So we should consider having the same levels of security in relation to setting a password at the beginning, so that every time you have a conversation with that client, they have to give you the password so you know who you're speaking to. And same with verifying the details of anybody that you're sending money to. Make sure there is evidence of all of this, because I have seen in practices whereby they've called for help or advice, where they've said they've lost money, they've lost client money, the SRA gets involved, and the first thing they do is they want to see the evidence of the fact that you check that information with the other side or with the client. And again, evidence is key. If you haven't got the evidence, it didn't happen. You're on a back foot, you've got no defence. So we want to see attendance notes, we want to see file notes in the case history of who was spoken to at what time and what number, etc., etc. And procedures for communications with the practice's bankers. You might have heard about my scary story where the SRA talk about practice that had their phone lines hacked and managed to talk somebody into calling them back. Well, when they called back, the phone line was still open to the criminals. Nobody in the office noticed. The whoever it was in the accounts department ended up moving money and moving that money to the criminal's account rather than to another secure environment. And you don't know what you don't know. So procedures for communications with the practice's bankers, again, passwords are really good. And do think about, if you ever need to call the bank back, then use a mobile and not the phone lines, which could have been hacked and are still open to the criminals until such time as that call's been made. Phone lines get switched back over, and the next call that comes in is actually from the bank to say, why have you just moved this money? We know nothing about it. So those are the key areas where firms are struggling, and also key areas of risk where, if you do need to review what you have in place, even if you've done a previous review, then it's worth just casting your eye over those particular points that I've brought to your attention. So in terms of what happens next, where we're at, we're always looking at this CQS scheme as being a moving feat. The scheme is intended to be a working document. It is intended that the Law Society will constantly review and update based on the patterns and trends that they identify. Obviously, any information that comes to their attention from any third-party stakeholders, such as either the SRA or the legal ombudsman or lenders, for example. So best practice will be updated, key issues will be updated. So there will always be various updates to the core practice management standard and the scheme generally. We can expect over the course of the next couple of months to receive some communication from the accreditations office to inform you that there will be some new scheme rules, because the old scheme rules did not allow for an on-site assessment. So the new scheme rules will allow for an on-site assessment. Obviously, that was something that firms that were selected for the pilot, I believe a couple of them pushed back on that basis, that this is not in the scheme rules, so you're not coming. So they will be updated and be brought up to current requirements, because I think they're some years old, those scheme rules. We will have an updated core practice management standard, which will just be generally updated because there is reference in there to the Code of Conduct 2011, which of course doesn't exist anymore. And there will be the addition of one new core practice management standard. And I don't know the exact wording of it yet, but it will be something along the lines of firms must have a procedure for reducing or mitigating the risk of land registry requisitions. So you will need to, even if you've kind of already been through the core practice management standard and you've done that review. I know I've done mock assessments for some firms, particularly in your neck of the woods. So even if you've gone through that process, then do be mindful that this is always going to be updated. So there will be additions. So when we're talking about land registry requisitions, we're not necessarily talking about the complex requisitions. We're talking about the transfer that's been submitted with the AP1 that doesn't include, the client's names or the client's full names, or the signature's not been witnessed, or, it's not dated. So the silly little things that land registry are taking, obviously expending a lot of their time dealing with that, shouldn't be happening. So you'll need to put into place a process, some kind of process where there is, a check made against various, pieces of information before the AP1 submitted, for example, to land registry. So that's something that you'll have to come back to. There will be additional guidance for firms. So Law Society over the last couple of years have been improving the guidance. They've been reviewing their documentation. So that will be available for firms once they've issued the communications to say it is available. And of course, there will be the official launch of the on-site assessments that I think I've been talking about for about 3 years now. So we were originally going to start the assessments at Easter 2020, so not long after I saw some of you guys in Guildford, but of course COVID hit. And so we've lost a couple of years. Last conversation I had with the Law Society, which was at the beginning of December, was that they were going to be issuing communications within the next couple of months to firms to say, this is what's happening, new scheme rules, new core practice management standard, new additional guidance, and be assessment ready from the 1st of April 2022. I have no up-to-date information on the back of that conversation. However, I would say that we heard the word Omicron probably about 2 or 3 days later. So there may be some delay to that, suggested CQS assessment ready date. And it might be the assessments aren't delayed. However, they might look different. It might be that instead of actually being on site for 1 day in your office, we might do some of it remotely. We might reduce the amount of time that we spend in the office. So there's a bit of flexibility in what those assessments will look like. However, they are forthcoming. They will be starting. So if you are the SRO and you get the newsletters from the accreditations team, keep your eye out for those newsletters because that will give you the information. And secondly, when you are selected for assessment, whether it's from the 1st of April or another date, further into spring and summer, you will be notified as the SRO by email that you've been selected for assessment. So please don't just delete them thinking that it's spam or there's nothing in there you need to know about because it's very clear that in the next few months you will need to be keeping an eye on those emails. And then finally, for those of you who are Lexel accredited, you will also be notified that there will be a new version of Lexel. So that will be Lexel version 7. There is a 50% overlap as it stands at the moment between Lexel and CQS. But for example, all the numbering is different. So CQS AML requirements are 1.3, Lexel AML requirements are 5.13. So there will be some alignment in, how the two standards are kind of set out. So it's easier for firms to cross-reference. And come across an awful lot of firms in the last couple of years that are CQS accredited, that aspire to being Lexel accredited. to help the professional indemnity insurance and the risk profile, and to gain consistency in the operational practices. And they've seen this as a good opportunity to take baby steps. So, get all your ducks in a row for CQS, and actually then move on to, to the other requirements that appear in Lexel but don't appear in CQS, and take those next steps. So by having that alignment and numbering, obviously, and chapters will help firms. So that's what's happening, and when it is happening, those are the areas of difficulty that firms are struggling with, and hopefully that kind of sets your focus in particular areas that you may need to go back on, or may want to review. Obviously, I've only picked out particular areas of difficulty. I've not gone through the whole of the core practice management standard. That's the 3-hour or 3-hour plus course that I ran back in January 2020 in Guildford, and I think Helen might be looking to run that again later in the year. When face-to-face training comes back in, or can do it remotely, that's not an issue, for those firms who haven't had the full experience of understanding what you are supposed to be doing to meet those 34 requirements, or 35 requirements when we get the new standard. So hopefully that's given you some valuable information as to key areas of difficulty, and how you can improve what you're doing in practice. If anybody's got any questions, then now's the time to ask. Whether you type into the chat box or want to speak to me, that's not an issue. Or alternatively, for those of you who haven't come across me before, there's my contact details. So tend to not answer my phone very often because I'm always doing things like this. But if you want to drop me an email, you want to have a chat, you want to run something by me, that's not an issue at all. Or of course, if you need any assistance going forward, or any recommendations in relation to those specific areas of anti-money laundering or data protection or anything like that, obviously I do have contacts who are experts in those areas. I don't consider myself to be an expert. I just have a very good working knowledge. Hannah has just sent me a message to say, are your slides available to download? I sent them over to Helen this morning, so they will be emailed out to all of you at the end of today's session, or following today's session. So thank you for listening. If nobody's got any questions, then I just say good luck on your journey, and I'm sure you'll have a good CQS assessment.
Well, thank you, Tracy. That's, as mentioned, that there will be some links to the recording of the session the next few days along with slides. And so if you've got any feedback on the session or the wider program, then do send that to helen.op@surreylawsociety.org.uk. I think we'll wish you all a good day.
Thank you very much. Have a good day, everybody.